Hello, I'm Paul Shamplina. Most people know me as the landlord's friend. It's my job to give landlords just like you guidance on some of the issues and laws that are affecting your property and your business. So I've teamed up with Deregulation for Business, the landlord insurance provider, to give you a series of videos to help answer some of the big questions on landlords' minds. This episode will focus on dealing with new changes to the Deregulation Act. The new Deregulation Act came into force on the 1st of October 2015, and it was brought in by the government to tackle rogue landlords in the industry and protect tenants against unfair eviction where they have raised a legitimate complaint about the condition of their property. Luckily, rogue landlords are in the small minority. The Section 21 notice is named after Section 21 of the Housing Act 1988 and provides a way of regaining possession of your rented property in England and Wales. Other jurisdictions will be similar, however there are some important differences, particularly in Scotland. For more information on this, check gov.uk. Landlords are now required to provide the following documentation to all tenants prior to the tenancy agreement. 1. A tenant how to rent guide, which you can get from the government website. 2. A valid energy performance certificate. 3. A valid gas safety certificate. You also need the tenant to sign and confirm that there are working carbon monoxide and smoke alarms in the property. This all needs to be given to the tenant prior to them signing the tenancy agreement. This will provide you with proof that the tenants have received everything required by law. Also, under the Deregulation Act is something called retaliatory eviction, which again was brought in by the government from the 1st of October 2015. I actually went to Parliament in 2014 to give evidence to a special committee on this very subject. So what is retaliatory eviction? This is when a tenant complains about disrepair at the property to the landlord, and instead of making repair, their landlord serves them with an eviction notice. So what is the correct process? When a tenant makes a genuine complaint about the condition of the property, they need to do this in writing. As the landlord, you have 14 days to reply. This is so you can advise when you can carry out the repairs and when you intend to remedy any problems in the property. However, if the landlord ignores those requests, then the tenants can go to the local council and speak to an environmental health officer who will visit the property. They can then serve an improvement or a hazardous notice on the landlord. If the council serves an improvement notice, then a landlord is no longer able to serve a Section 21 notice within 6 months. For any tenancies after the 1st of October 2015, there are other new changes to Section 21 to be aware of. Make sure you use the new Section 21 form. You don't have to put a specific end date on the new Section 21 notice like you did before. You're unable to serve the notice at the beginning of the tenancy. It's only after 4 months into the tenancy agreement that you'll be able to do so. Once the notice is served, you have 6 months deadline to issue proceedings to the tenants. So here's the thing, landlords. There are a lot of new changes and it's quite time consuming to keep up to date with them all. Regulated letting agents can help with this. The law is there to protect everyone, so don't take it for granted and make sure that you do everything you're legally required to do so that your rental runs smoothly. To help you manage your property more effectively, why not download the free mobile landlord app from Deregulation for Business? The app can help you manage your property portfolio, securely store important tenant information, and helps you keep track of your income and expenditure.